Judgment in the appeal, Jackson and Murray and another.
Lord Reid will explain the decision of the court.
Where a person suffers damage as the result of the fault of another person, she is entitled to recover damages from that person. But where the damage is also partly the result of her own fault, an Act of Parliament requires the damages to be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. This case concerns a situation of that kind. A child was run over while crossing the road. The driver was at fault in driving too fast and failing to keep a proper lookout. But the child was also at fault in failing to take proper care to cross the road when it was safe to do so. So the court is required by Parliament to reduce the damages awarded to the child to such extent as it considers just and equitable. The judge who heard the case decided that her damages should be reduced by 90%. On appeal, the inner house of the Court of Session decided that that was too high a reduction. They said that the damages should be reduced by 70%. The child, who is now grown up, says that that is still too high a reduction and appeals to this court. The first matter the court has to decide is the basis on which it is entitled to interfere with the assessment made by a lower court. A question as to what reduction is just and equitable is not one to which only a single answer can be given. Different judges may reasonably take different views of what is just and equitable in a particular case. The court holds that those different views should be respected within the limits of reasonable disagreement. Before an appellate court can interfere, it must be satisfied that the court below went wrong. That means that there must either be some demonstrable error, such as a misunderstanding of the facts of a case, or the court below must have gone beyond the range of decisions which were reasonably open to it. All the members of the court agree that that is the approach to be followed. They differ, however, as to the result of applying it in the present case. The accident occurred shortly after a school minibus stopped on a country road to drop off two children who lived on a farm on the other side of the road. It was a main road with a 60-mile-an-hour speed limit and no street lighting. It was getting dark and the cars had their lights on. One of the children, who was 13, crossed the road from behind the bus, either without looking carefully enough or without taking sufficient care to judge the speed of a car which was coming towards her. The driver could have avoided her if he'd been driving at a reasonable speed and keeping a proper lookout, but he was not. He saw the bus sitting stationary with its hazard lights flashing, but he did not slow down or watch for anyone trying to cross. He did not see the child emerging from behind the bus, but he was travelling too fast to have stopped even if he had seen her. He hit the child, and she was severely injured. In that situation, a minority of the court consider that the decision of the inner house to reduce the damages by 70% is not unreasonable, since the child must have been highly careless to have crossed the road at a time when the car was only a short distance away. But the majority of the court take a different view. They do not understand why, on the evidence, the inner house considered that the child should be regarded as bearing a much greater share of the responsibility for the accident than the driver. It is true that the child must have been careless, and that if she had waited until the car had passed, the driver would not have hit her. Equally, if he had been driving carefully and had slowed to a reasonable speed and kept a proper lookout, he would have avoided her. She was a child, he was an adult. She was a pedestrian, he was driving a car at speed. She failed to react properly to the proximity of the car, he failed to react properly to the presence of the bus and the risk that someone alighting might attempt to cross the road. As it appears to the majority of the court, the driver's conduct played an equal role to that of the child in causing the damage and was equally blameworthy. The view of the majority of the court that the parties were equally responsible is substantially different from the view of the inner house that the child was much more responsible than the driver. Such a wide difference of view goes beyond the ambit of reasonable disagreement. The court therefore allows the appeal and awards 50% of the agreed damages to the appellant.
Thank you. The court is now adjourned.